Good afternoon, my name is Juan Manuel Blanco and this is your channel of international contracts. Today we are going to talk about which rules govern the contract that support your negotiation. So keep watching. First of all, we need to know what is an agreement and what is a contract. An agreement is an understanding between two or more parties, and a contract is a specific type of agreement that is legally and enforceable in a court of law. So, the law will consider a contract to be valid if the agreement contains the following statement. The first one is the offer and acceptance. Next one is the consideration to be paid. Also, the intention between the parties to buy. The other one is the legal capacity of the parties. Also, the genuine consent of the parties. At last, but not least, the legality of the agreement. In any international contract negotiating of a product, it's important to pact between the parties in Incoterm, because this is how they are going to work in all the negotiation. These represent an international term that defines the transaction between the importer and the exporter. And why this is important? Because it shows the responsibility, the task, the risk, and the cost of the transaction of any international trade. Also, we use the lex mercatoria because it has many rules that are recognized and applied for the general acceptance commerce rules, and also that surpass the political boundaries of international transactions. Who provide these rules? UNCITRAL is the core legal body of the United Nations of the file of international law. UNCITRAL is specialized in the harmonization and modernization of the international law and all kind of negotiation around the world. Our next question is, who is to decide possible disputes? In an international contract, a jurisdiction clause specifies which country should hear a dispute. And this dispute can be seen in different ways that I'm going to explain you. A mediation. A mediation is a third party that help the disputants to do consensus for solve all the disputes. Next one is the arbitration. The arbitration, the third party became as a judge with evidence of the disputants. The decision of this judge is confidential and also it can be appealed. The litigation is with the defender and the accuser. They provide information from the public record to solve all the disputes. Also, the disputes that are solved in a court by a judge, it can be in two different legal rules, the common or the civil law. Common law has an extensive use of rules. Judicial cases are regarded as the most important source of law, and the judge has the most important power in all the court. In civil law is a system that are using codes and statutes. This is covered to all the eventualities of the cases from that are studied by a judge. In this case, the judge has not the same power as the judge of the common law. Thank you for watching this video. I'm Juan Manuel Blanco and keep watching our videos of international contracts.